Hi everybody, this is part 3 recording of involuntary manslaughter and the final recording for this area of law. So I'm going to take you through what is required for an essay in this area, and at the end I will show you a typical question and one that OCR have used on one of their practice papers recently. So the general plan for an essay is that you start by describing the area of law, and as you know, for OCR you gain 10 marks for describing. You should aim to use at least 5 relevant cases and or legislation. Of course, in this instance these areas are common law, so there is no legislation, so you need to use case law, and you could use more than 5 because we've looked at a lot of cases over the last 2 parts. So you start by describing, and then what you could do is go into your criticisms, your evaluation points, and I've set out a general plan at the bottom of this slide. So you could start by generally critiquing and evaluating the areas, and then drilling down into each type of manslaughter. And a really good way to do this is to pick apart the tests, so stage by stage, and evaluate like that. At the end, obviously, we need a conclusion, a summary, so no new information should go into a conclusion. It should simply be a summary of your points and any suggestion for reform. So I'll take you through those. So I do want you to take your time and make sure you write these criticisms down. And this PowerPoint is quite wordy, but that's because I really want you to have all of the points. So you should have these in your booklets already, but do make sure you write them out again and really take your time to consider whether these are well-developed points. Remember, that's what we're working towards. Are they explained and evidenced as fully as they could be? Is there anything else that you could say to gain more marks? So a couple of general criticisms. Firstly, involuntary manslaughter is of course different to murder because of the mens rea. So there is no need to prove intention to kill or cause serious harm, i.e. malice aforethought, for manslaughter. Therefore, manslaughter is commonly used as an alternative. So the Crown Prosecution Service will often charge a defendant with both murder and manslaughter if they feel that at trial they might have difficulty proving an intention to kill or cause serious harm. Manslaughter therefore operates as a fallback crime, which enables the prosecution to secure a conviction, albeit not for murder, but a conviction nonetheless. Remember, if they don't charge in the beginning, then they will not be able to put that crime to the jury. And therefore, if they only charge murder, if a jury acquit, then that's their lot, if you like. They don't have a second chance unless new evidence comes to light. So it is a common fallback crime, and leading into the second point, as a result, it's really wide, which could be criticised because there are a number of ways that you could find somebody guilty of manslaughter. So across the 3 types of manslaughter, they cover both positive acts and omissions. So whichever way you act or fail to act, that could, if that leads to a death, then that could find you guilty. Even acts like committing an assault, which, as we will look at when we learn non-fatal offences, that is not a physical action. That is simply doing something that causes a victim to fear. Even that could lead to a charge of manslaughter, as in the case of Lamb. Now, if you need to go back to Lamb to recap the facts, please do. And you'll remember that Lamb was found not guilty in the end, but he was charged with the manslaughter of his friend on the basis that his friend feared force was going to be used against him. And of course that was thrown out, but initially he was charged. And the wideness of this can also result in inconsistencies in sentencing. And two well-known authors, particularly in criminal law, Smith and Hogan, have talked about this. Now, when we're back to school, we do have some Smith and Hogan's criminal law textbooks in the library, so you can always have a little look at what they say about this in more detail. But with sentencing for fatal offences, particularly murder and manslaughter, you should be looking at a life sentence. Of course, for murder, that's a mandatory life sentence. For manslaughter, it falls to discretionary. And that is extremely wide-ranging. If you look at the Sentencing Council guidelines online, they're available to the public, you will see that there are a range of different starting points for sentences for this area. So that could really be applied inconsistently across the country. Remember, of course, a judge will always be sentencing in the Crown Court for this type of offence. So we would hope that that would be more consistent. We don't have a jury deciding sentence. And of course, because this is an indictable offence, magistrates would never decide. So inconsistencies should be fewer, but ultimately every case has different facts. So we could see some inconsistencies applied there. Thirdly, there is a general confusion between the different types of manslaughter. So we have one that is committed by a positive act, and that's the unlawful act manslaughter. The other by omission, and that's of course gross negligence manslaughter. But then we have this third type, reckless manslaughter, which arguably overlaps with the two because it can be committed by act or omission. So of course it's long been debated as to whether it's actually needed, but we know in the case of Lidar in 1999 the Court of Appeal said that there is a place for reckless manslaughter, so it's here to stay for now. So going into specific criticisms, starting with unlawful act manslaughter, again, as I say, take it step by step through the tests. So in terms of determining the unlawful act, it can be difficult to determine what that act is. Some acts may not actually be unlawful, Lamb being a good illustration as we discussed, or may be difficult to find. So of course there are a number of drugs cases where the courts have struggled to identify what the act is to be able to link it to causation. So we've seen the development through Cato saying if you inject a drug user, then you are administering that drug and therefore that is an unlawful act that has caused the death. But of course in other cases like Dolby and Kennedy, if you are simply, I say simply, supplying drugs and that victim then chooses to administer them to themselves, then that is not an unlawful act that causes death for the purposes of manslaughter. And you may remember me mentioning the case of Rogers from 2003, where the defendant did assist the victim by holding a tourniquet round their arm so that they could inject themselves. And interestingly, the court there said that they couldn't actually determine what the unlawful act was. Now, of course, the defendant did help the victim administer the drugs, and the victim died of an overdose. But the court was unclear what the unlawful act is, which really helps to prove this point of the difficulties. If the courts have difficulties, then of course lawyers and those unrepresented will also have difficulties too. The act needing to be dangerous for the second part test can be criticised because it's purely determined on reasonableness, objectiveness. So you're not thinking or about what the defendant viewed at the time. You are simply applying to the standards of a fictitious person. And this can be difficult for juries to grasp. Of course, it is a matter for a jury. They have to apply the facts to this test. And across a panel of 12 jurors, every person may have their own view on what is reasonable and what isn't. So that can make this unfair and of course lead to inconsistencies and maybe unfair or unjust verdicts. And kind of building on that with the third part, the defendant doesn't need to realise there was a risk of harm. So, and that ties in really nicely with the act needing to be dangerous. This is all wholly objective. But another point to note is that actually this test is quite inconsistent with other areas of law. So to be guilty of a non-fatal offence, so an assault, battery, ABH, GBH, there needs to be foresight on the part of the defendant. So the defendant either needs to have intended to cause the harm or be reckless. And of course, reckless is where you have the view that some harm, that there is a risk that harm will be committed. Now, that completely contradicts what is needed for manslaughter. A defendant doesn't need to have seen any risk of harm. And it would follow that surely because this is a more serious offence, a death has been caused and you're looking at potentially life in prison, that there should be a foresight of harm. So the Law Commission has criticised this in previous reports. Just something to note there. The third part of the test in terms of causation, we talked about the issues with causation before, about the but-for test and the more than the minimal cause test. These are really wide and you are 9 times out of 10 going to find that causation is established. So, but for the defendant's actions, we can always relate things back to the original act. So, but for the defendant's actions, the victim wouldn't have been in the car or on their way to a hospital or in hospital. It's that chain of events we can always make out. And of course, the defendant's actions being more than the minimal cause only requires a link. They don't have to be the sole or main cause. They only need to be linked. So those are really wide. And of course, we do have the intervening acts that can break this chain of liability, but even if present, they may not still break the chain. And medical treatment is a really good illustrative example. For policy reasons, courts will be reluctant to find medical professionals guilty of manslaughter if the victim was there for some unlawful reason and needed treatment. So it would only really be cases we've looked at like Jordan where doctors make really seriously wrong mistakes that they would break the chain. So there's a lot to say about gross negligence manslaughter in terms of criticising. Firstly, of course, this is an area based on civil principles. Should it be a criminal offence at all is the first question. But of course, what turns this into a criminal offence is the element of it needing to be gross, and it can be difficult to determine what is meant by gross. Now, courts have tried to give some guidance to this, and what they talk about is there being or needing to be a risk of death. Now, if I skip down to my fourth point, the jury decide this. The jury decide whether the breach is gross and whether there is a risk of death. And they're also directed to decide that the breach is gross if they believe the defendant's conduct is criminal. Now, there have been some criticisms about this because if the jury believe that the conduct is criminal, then of course they will always believe that the defendant is guilty of this offence because it will follow that the breach is gross and therefore this should be a criminal offence. So there have been some criticisms about this being rather a circular test where the jury are always led back to the same conclusion. So it's just something to think about. And of course, going back to the second bullet point here, we have a number of duties that we can apply to situations, and if we're unclear, we can always go back to the original negligence principle in Donoghue and Stevenson, where we determine whether somebody is your neighbour in law, that person closely affected by your acts or omissions, But the more recent duty to mitigate harm and save lives is unclear. So we know presently it's been applied to an extended family situation, but of course we need to see what the courts do with this in terms of how do they apply it. It could almost create a Good Samaritan law, so where we are required by law to help a member of the public who is struggling, which of course morally we would feel that way, but legally we are not bound to do so. So really we're waiting on the courts to clarify and interpret the extent to which we are expected to help in a typical dangerous situation. So that could be a suggestion for reform, a bit more guidance on that. And of course, in terms of the duty, for the third point, we may not even know that a duty is imposed upon us. And then we are found to be liable if there is a death, liable in law. And of course, I go to the public office duty, the case of Dytham, where he was off duty as an officer. Now, there are two sides to that argument, of course, as to whether he should have been found responsible for the death of the person involved in the fight. But what it does almost is place strict liability on people. You could find yourself convicted of gross negligence manslaughter and you didn't even know that there was a duty imposed upon you. Of course, the voluntary assumption of duty is a good one as well. You take somebody in and look after them with goodwill, and then they end up neglecting themselves, or something happens and they die, and you find yourself responsible for an indictable offence. So in summary for this slide, you've got issues with the duty of care and the extent to which that places duties on people. You've got issues with what is meant by gross negligence. Of course, that breach of duty must be gross, and we are requiring the jury to make that decision, which again leads to issues of confusion. I mean, the role of the jury is to decide facts, not law, but if they are deciding whether an act is actually criminal, then that is going into the realms of lawmaking or law deciding rather than fact deciding, and that's the issue for critics there. Okay, so reform is obviously really important. You can always have a look at the Law Commission website, it's lawcom.gov.uk, to see whether they've reported on a particular area that you're reviewing or learning. I would recommend that. Their reports are often really lengthy, so don't worry about ever reading a full report. You can skip to relevant parts and just gain a summary of what they're suggesting. Usually that happens quite early on in the report, and you can find your way through the contents pages. But the Law Commission has reported on this area of involuntary manslaughter several times. So if you look here, 1994, 1996 and 2007, although I believe for 2007 the report, it was murder, manslaughter and infanticide. That was actually dated 2006, so just make a note of that report, murder, manslaughter and infanticide. And what they've recommended over the years is that the area be codified, of course, so let's put it into a piece of legislation, because we haven't got that for manslaughter as well as murder. We only have that for the voluntary manslaughter defences, don't we? And this area be simplified into two types of manslaughter. So they want, or they've asked for, unlawful act manslaughter to be replaced with an offence that at least requires an awareness of a risk of death. Because, of course, the main criticism we talked about with unlawful act manslaughter is that the defendant doesn't need to have been aware of any risk of harm, let alone risk of death, as is needed in gross negligence manslaughter. So they're quite contradictory and conflicting. And they would call this crime reckless killing. They've also suggested for gross negligence manslaughter to remove the term negligence to avoid confusion and replace with carelessness instead, and then that would deem it to be more of a criminal offence rather than keeping that link to civil. So as I say, you can spend some time looking at reform in this area to make sure that you have a really good understanding. The report Murder, Manslaughter and Infanticide would be a really good one to look at here. Okay, so now that you hopefully have a better understanding of the evaluation in this area, I have a task for you. So have a look at the essay title. It's in bold. It is discuss the extent to which the law on involuntary manslaughter is unsatisfactory and in need of reform, for 25 marks. 10 of those marks being for your knowledge and understanding of the law, 15 marks being for your evaluation. Now, of course, discussing the extent to something does lend itself to a bit more of a balanced argument, and what I've done for the last 20 minutes is criticise it. If you can think of any positives, please do add those in. There are fewer positives than there are negatives, of course. This question was on a practice paper for OCR, and of course part of the question is about whether it is in need of reform, so you do need to make reference to the suggestions for reform, particularly by the Law Commission, that have been proposed. So I've covered a lot of evaluations, so what I want you to do is choose at least 5 points across those evaluation slides to answer the questions. You've got 3 evaluation slides, 1 on general criticisms and 2 on specific criticisms. Choose 5 points to develop and use to answer this question. Those plus your AO1, a conclusion and suggestion for reform should lead to 25 out of 25. And I look forward to receiving those answers. If you have any questions, please do let me know. Thank you.